The Vermont Supreme Court has made a ruling that is actually really bad related to the Second Amendment. Sit by and watch this episode of Guns and Gadgets to learn more. Just know that this cannot be allowed to stand. Hey everybody, welcome back to Guns and Gadgets, your premier source for Second Amendment news. If it is Second Amendment news you're after, if you're interested in the constant fight to repel the ridiculous amount of infringements against our right to keep and bear arms, then you have found the spot. Please subscribe to Guns and Gadgets. I try to have a video at least once a day, and I hope that this brings you the information you seek. And before I jump into the Vermont State Supreme Court ruling, I'd like for everybody to check out the USCCA. Click the link down below. It'll open you up to a world of training and education, and also self-defense liability insurance, because things can happen anywhere in a blink of an eye, even in a gun shop if you look what happened in Louisiana. So have protection that can protect you when it's time for you to protect yourself or others. Click that link down below for the USCCA and check them out. All right, guys. Let's talk about this case here in Vermont. So in 2018, Vermont, which has always been constitutional carry and is up till today, they passed a magazine ban in the wake of the Parkland shooting because of feelings, okay? And what their magazine ban is, I'll explain it real quick. For a long gun, you're limited to magazines no more than 10 rounds because that 11th round makes you an assassin. For handguns, no more than 15 rounds. And there was a grandfather clause as well. Now, for some people, like those who live in states like Massachusetts, we would salivate at the 15-round mark because we're limited to 10 across the board. But however, regardless, it's an infringement, right? Because who gets to set an arbitrary number and to tell me how many items I can use to defend myself? But we all know that. I'm preaching to the choir. So a case was brought against a guy who was charged and accused with traveling from Vermont to New Hampshire, purchasing two 30-round magazines for a rifle, and coming back into Vermont, thus violating their magazine ban because those plastic tubes with a spring could hold more than 10 freedom seats, okay? So he fought, obviously, and in 2019, the case was upheld. The ban was upheld, I should say, by a Superior Court judge. That judge's name is William Cohen. And why do I say his name? Well, William Cohen, the judge, now is on the Vermont Supreme Court. However, he was recused for this case, but that doesn't mean that the other justices weren't picking his brain. You know, maybe they weren't in the mood of overturning a ruling by one of their teammates, right? So let's fast forward to this case. On Friday, the Vermont Supreme Court released a 51-page decision upholding the Vermont magazine ban as constitutional. Now, the case, as it was fought, was challenging that the magazine ban violated Article 16 of the Vermont Constitution. And the Vermont Constitution, Article 16, I'm going to put here on the screen. And it says that the people have a right to bear arms for the defense of themselves and the state. And as standing armies in time of peace are dangerous to liberty, they ought not to be kept up, and that the military should be kept under strict subordination to and governed by the civil power. Vermont, again, has been constitutional carry from the beginning of time, and it is an extremely safe state. There's a very, very low crime rate in Vermont, and there are actually more cows than people there. Fact check that. But there was no need for this magazine ban. It was a knee-jerk reaction following Parkland, and it was signed into law by their governor, Phil Scott, a Republican, okay? Now, part of the arguments made in this case was that the Article 16 is without limitation. However, obviously the state attorney general thought that there should be limitations to your right to keep and bear arms. And then Friday, the decision came out, and it's dangerous. If this thought process that the justices used in making this decision spreads, guys and gals, this will be a very tough one. So in their decision, the justices found that the right to bear arms for the defense of themselves and the state likely referred to participating in a state militia, and they said that this makes it, quote, essentially obsolete in the modern world. Now, they did say that that clause allowed for the right to keep and bear arms for self-defense, but they did say that that would be subject to limitations and regulation. They also wrote that whereas we have previously relied on stated or unstated assumptions that the individual right to bear arms in self-defense exists but is not unlimited, we now expressly hold as much. They said that the government could regulate firearms under the state constitution as long as any enactment is a reasonable exercise of police power and there is a reasonable fit between the purpose and the means of the regulation. They're saying that it's okay to be a police state, basically, as long as they were saying on paper that it's for the safety of the public, then by all means, go for it. They also said that the magazine ban was a minimal burden on the right to keep and bear arms. And they even said that large capacity magazines are rarely used in self-defense situations. No, that's wrong. But how did they come up with this information? Well, it's well-known information. In fact, the FBI publishes this stuff every year, and that's the old 3-3-3 rule, right? The average shootout is 3 rounds or less in 3 seconds or less at 3 yards, and that's what the Vermont State Supreme Court used, saying that if this is the average shooting amount, then why do you need 15, 17, 19 rounds, etc.? Perhaps in Vermont they don't have cable yet, because if you look at how the mobs are attacking people, it's going to be more than 3 rounds nowadays if you're fighting for your life against, the cancel culture mob that's coming to stomp a mud hole in your ass. But, facts smacks. So I'll have a link to the 51-page ruling down below in the Vermont State Supreme Court's website there, and it's dangerous. So this ruling is basically saying that the Second Amendment, at least as written in Vermont's state constitution, is obsolete. That's extremely dangerous because shall not be infringed means something. And although it doesn't say it specifically in the Constitution of Vermont, where it says shall not be infringed, actually means that. I don't know why that's so hard to understand. But hey, let me know what you think down below. If you're new to the channel, please let me know what you think, and hopefully you'll stick around. You can hit that subscribe button. Also smash the thumbs up. Share this with about 762 of your friends. That'll help the news get out, because we are on platforms that don't want this type of news to get out, even though it's 100% legal to talk about your rights. Also, don't forget to check out the USCCA, and thank you for your time. Until we see each other again, be safe, stay vigilant, carry a weapon, and I'll see you on the next one. Take care, everybody.